to any matter or thing done or to be done in Madhya Pradesh. So if it relates to property in Madhya Pradesh, I have to, if the property has to be mutated in my name, I have to present it. To any matter or thing done or to be done in Madhya Pradesh. I can wait, my lord, when I have to do it. There is no compulsion that the document has to be executed, to be produced the next day. I can do it when it's necessary for me to do it. Business exigencies, my lord. When it's necessary for 3DB, very clear, and relates to any property situated or to any matter or thing done to be done in Madhya Pradesh and is received in Madhya Pradesh. Well, this received in Madhya Pradesh cannot be received in the hands of the person, because it's always in the hands of the person. Received in Madhya Pradesh is some authority receives it in Madhya Pradesh. Any authority. I'm not saying necessarily stamp authority. That would be a very narrow interpretation. If I produce it before any authority in Madhya Pradesh, who is a statutorily exercising something which I have to be done or to be done, that is a document. If he is not the stamp authority, what he will do, he will impound the document and refer it to the stamp authority. If he is the stamp authority, he will stamp it. Therefore, received can only be received in Madhya Pradesh, received by a governmental authority in Madhya Pradesh. I can give it to my manager. That is not received in Madhya Pradesh. It is received in Madhya Pradesh only for the purpose of stamp duty.
Even impounding says so.
Even impounding section 33 of the Stamp Act, yes, which is what I just now said.
Impounding.
No, 33 becomes relevant. Please read 33. Every person having by law or consent of parties authority to receive evidence, and every person in charge of a public office before whom any instrument chargeable in his opinion with duty is produced or comes in the performance of his functions shall, if it appears to him that such instrument is not duly stamped, impound the same. Once he impounds it, he refers this to the collector. Now, this is according to me, consistent with the day-to-day practice. I take it to various authorities if it's a nationwide operation. I don't have to take it to all the authorities on the same day. When I have to get something done or to be done, I take it to an authority. If it is not stamped and if he thinks it's stamped, he will impound it under 33 and refer it. Now, in this case, they have now yesterday, according to them, got documents which was not before the learned single judge, not before the court, not before the impugned order authority. They have come across documents which, according to them, points out that the document was produced before an authority on 29/3/2017. That is the fourth date they are propounding. 2 dates we propounded. Learned judge found a date. Third date. They may be right, they may be wrong. I'm not willing to state anything unless I take instructions to my clients. The fourth date they are propounding. Now, which of the dates I submit, Mullah, with great respect. I think I'm a good legal authority to support that. In certiorari jurisdiction, your lordship will not fix the date. You send it back to the authority, point out the controversy, and say you decide according to law and the evidence. Anyway, the matter is remanded.
No, Mr. Chidambaram, let's test the counter filed by them.
Yeah.
They're saying you presented it before an authority on.
That's what they said.
Now, assuming you also accept that, yes,
I have not taken instructions.
That's why I said, assuming you also, your instructing counsel takes instruction and instructs, yes, that was the day he presented it first.
Yes.
Then where is the question of sending it to an authority to assess what was the date you accepted? if you accept it as the trigger date, then the calculation will take place, even in these 2 to 6 proceeding.
Oh my God. Question is, did I present those documents to an officer?
So take instruction on that. If you have, then at least that
Did I
part of the control.
presented that document to an officer? Because what they have filed is, they may have another document, I don't know. What they have filed is the 2-page order by the judge, but the scheme has not been filed in the compilation. Now, what is the implication of that? I will take instructions and your lordship will finally find. The scheme of amalgamation runs to 400 odd pages. The instrument is the scheme of amalgamation. They have filed a 2-page order of the NCLT Allahabad. They have not filed the 400 odd pages of scheme of amalgamation. Whether it was there in the file or not, I don't know. I may request the learned advocate general give me inspection of the file, subject to your lordship's orders.
Now, if you see page 9 of their list of documents,
Yes. They are
serial number 2.
now, the new document, Milak?
Yes.
The new document.
Page
Yes.
9, the serial
Yes.
number 2.
Yes.
Yes.
It says list of certified copy of NCLT Allahabad order and scheme of arrangement.
That's what it says.
That's right.
But
So
what they
take
have
instruction
filed
is a
is-
possible. Here
What
they
they
have
have
not
filed
annexed
is
it.
only 2 pages.
Here they have not annexed it.
Why
but
not we,
I
please
don't
make
know.
record, there is no, why not so as to avoid bulk.
I don't
of
know.
that
That's all right.
I'm
Yeah,
not,
okay,
I'm not complaining.
Mr. Chidambaram,
Yes.
we're not binding you down today.
Yes.
Please take instruction because this seems to suggest that probably it was submitted. You find out if that's the date, we'll freeze the date and direct them to assess in terms of the learned.
That is one important thing.
Look,
Why
that
not-
is not the only issue. That is not the only issue. I am only treating that issue in the light of their affidavit. And since the matter has already been remanded to the authority, that this issue also should be remanded to the authority. But if your lordships feel that that question can be decided, I'm not coming in the way. All I'm saying is it would be appropriate to remand it to the authority, along with the other issues referred to by the learned single judge. This issue of what is the date on which the document was received in Madhya Pradesh should also be remanded. That is what I'm saying. But if your lordship thinks otherwise, I will come back, file a reply and inspect the file and then make my
Why
submission.
not
Whichever.
what I respectfully submit. Why not we have moved an application raising objection with regard to maintainability of this data appeal. Why not my learned friend has not addressed on that application, no reply is filed to that. And now, my lord, your lordship,
Why is
we
it?
raised the objection with
why
regard
is
to
the
the
writ appeal
suitability
not
of this writ appeal.
Ah,
The copy valid time was applied to the other
Why
side.
is the writ appeal not maintainable?
But my lord, we have come out with a case that my lord, the collector staff has adjudicated the issue
No, this is an order. What is being tested here is an order passed in a writ petition under 226.
under Article 227. This is what our humble submission is.
That 226.
So, my lord, we raised that objection, but you,
Well, the learned judge by a separate
what
order,
I'm
judged by a separate
that's
order,
fine.
held,
What your
this was
lordship-
under 226 and the objection was not maintainable.
okay, but you need to address on
I
that issue.
understand.
Your lordship may kindly appreciate, my lord, there is an objection on behalf of the state.
If the learned single judge has held a writ petition under 226 to be maintainable,
Yes.
and you are not aggrieved by that order, you're not assailing that.
They have
order.
not appealed, they have not appealed that order,
No, my lord, not in the order which is impugned in this writ appeal. It
Even
is not
earlier,
there.
earlier order.
If
That's fine.
you've not impugned it, so why should we now reopen that?
Your lordship may kindly appreciate what has happened, my lord. Against the order of collector, there was a first appeal maintainable before divisional commissioner, and second appeal is provided before board of review. So at the initial stage, my lord, when this writ petition came up for consideration before learned single judge, we raised this objection, my lord, that it is the order which is assailed in the writ petition is appealable. So, my lord, that objection was turned down, and honorable single judge was kind enough to proceed further with the writ petition, my lord, dealing on the merits of the order.
Rejection of that order is not challenged by you.
No, that we have not challenged by.
I have the order.
That's all
No,
right.
it's okay. So now your lordship may kindly appreciate.
You are 25th November
I
2020,
think-
both
My
objections
lord,
were raised. Both objections were raised.
Chidambaram,
rejected.
he is conceding that that has not been taken up.
Very well, very well.
So Mr. Singh, he will, in case they admit that the date which you say is in your return as the date when it was first presented along with the scheme of amalgamation, then at least that aspect will be closed. The rest, the learned,
ठीक है.
can look at. So when should we have it?
Milord,
And my lord, since 2020, my lord, they have not paid anything.
We'll
So-
finish it just now, Mr.
Yes.
Weekdays, it will be over. It's not,
Milord, I will request the learned Advocate General to give me inspection of the file. I'll
find out, probably your clients would confirm, his clients will confirm it is
No,
there.
no, I want to see what was, because this is filed for the transferor, not me. Transferor is Jay Prakash. Therefore, he kindly see list of documents from transferor. If it is me, my lord, I would not answer. List of documents from the transferee is only certified copy of the order of the National
Yes,
Company
but
Law
if
Tribunal.
is
the
jointly
document
signed by
is
law.
received by the state.
I'm not disputing, I'm only want to inspect the file to see what the transferor filed. Miller, I can't be refused inspection of a file, Miller. I'm only asking for an inspection of the file. And it was not before the impugned order authority, the stamp authority. It was before another officer, mining officer, they say.
So then received in state, received.
No, I'm not quarreling on that. I only want inspection of the document today or tomorrow. Inspection of the document, time to file a counter and any other document, and your lordship may fix a date.
And in fact, this document,
Yes.
page 9,
Yes.
is annexure to a joint application submitted by both the transfer and
Joint
transfer.
Because application is joint. Application is joint.
Yes, so the annexure to that joint application, obviously you'll not submit 400-page document again.
I'm not saying one way or other. I'm only asking for.
They are required to file reply to it, my lord. They may
file a
come out
scheme
in their
for
stand,
learned
my lord, by
Advocate
filing
General.
reply.
I should also have the benefit of seeing the file, that's all. Milord, in certiorari, your lordship calls for the records, and the petitioner is entitled to inspect the file.
Your lordship may kindly appreciate, my lord, in the return before the learned single judge, we took a specific stand. My lord, that the 4 mining lease, they got executed at the instance of the petitioner, and that was the date when, my lord, the instrument was first presented in the state of Madhya Pradesh. My lord, there is no rebuttal to that government. My lord, before the honorable division bench, my lord, we have simply filed those documents so that the honorable court may have an opportunity to peruse those instruments, my lord, those documents. So we presented it, my lord. And so as to avoid bulk of this IA, we have filed only, my lord, the extract of these deeds, my lord, that we have filed. So my respectful submission is, my lord, if they want to file reply to this IA, my lord, they may file it. But before the learned single judge, my lord, their case was that they filed some representation.
Now, Mr. Chidambaram,
Yes.
analogy can be drawn from section 18 of the Stamp Act.
18, Milord?
18.
Yes. Yes.
Here also the expression first received in, this is for documents which are executed outside the country.
Out of India.
Yes. It is first received in India.
Yes.
So the receipt here is taken when it crosses the custom boundaries and enters India,
No.
not when it is presented for the first time before the collector.
To the best of my knowledge, no authority, no court has
No,
held. so.
that, Mr. Chidambaram.
Execution is by me.
No, your instructing counsel will instruct you because when you present a document to a stamp for stamping, if it is
Yes.
executed outside, first thing they ask for you is the postal envelope through which it has been received in India to determine the 3-month period. That's how the authorities have been interpreting it.
I have not mentioned the case law under 18 because that did not arise in this case.
No, it does not. But the expression received used in section 18
Yes.
and section 3.
I look at the case law. I look at the case law. Now, my lord, my learned Advocate General
We will ask that you.
has filed an affidavit. Now,
Yes.
please see paragraph 6 of the affidavit.
Paragraph 6 of the affidavit. The present affidavit, the aforesaid documents. Just a moment.
Affidavit in support of IA. Which affidavit? Acha.
Sorry. The aforesaid documents already form part of the pleadings of the return. Paragraph 6 of the affidavit in support of the additional documents.
Yes.
The aforesaid documents which he seeks to place already form part of the pleadings of the return filed by the answering respondents in the instant writ petition. This is the explanation to get over Order 41, Rule 27. Be that as it may. Please see 57, paragraph 57 of the learned single judge's judgment. Please see paragraph 57 of the learned single judge's judgment. Page 83. They say we had pleaded it, but we didn't place the documents. We are now placing the documents. Now, please see page 83, paragraph 57. Finding with 60, para 62. I'll read both paragraphs. The counsel to the petitioner submitted that in fact the date of receipt of instrument was 5/8/2019. That is my case. Although in the reply to the show cause notice, as well as in the writ petition, petitioner claimed the relevant date was 24/10. Although a very weak attempt was made by some states that the relevant date would be 29/6/2017, but thereafter the State Council changed its stand and submitted that only the date of execution of the document is relevant and not the date on which the instrument was received in the state of Madhya Pradesh. Now kindly come to para 62. For the reasons best known to the state,
the aforementioned documents have not been placed on record. However, an equally vague reply was given by the petitioners in their rejoinder. However, as already pointed out by so-and-so, 4 documents were mining lease transfer deeds and afforded deeds were got registered. Did not want that any mining lease should remain in the name of Jai Prakash, although it has not been clarified by any of the party whether a copy of the order passed by NCLT Allahabad was submitted at the time of registration of 4 documents or not. But one thing is clear, there is a clear reference to the order of NCLT Allahabad. Not only there was reference of order of NCLT Allahabad in registered deeds, but the execution of 4 mining lease transfer deeds clearly show that the petitioner had acted upon the order of NCLT Allahabad. Once the petitioner had put the instrument, order of NCLT Allahabad into operation and also got the mining lease transferred in its name, then it is held that even if the copy of the order of NCLT Allahabad might not have been filed, but still the reference of the said order and further action on the basis of the said order would certainly mean that the instrument was received. This is the learned judge's interpretation, which I respectfully submitted wrong. Received has been construed by the learned judge's reference. Well, your lordship will test that. But my learned friend's statement in the affidavit that this is documents for what was pleaded
in the return is wrong because there was no pleading, there was no document filed before the
Para
last
61
signature.
may have a,
Valid signature.
kindly have a look to
Now
para
it's filing
61.
the document.
Para 61, my lord, that, while understand that I have skipped reading of this.
No, I'll read
Para
that.
61.
61 or 51?
No, 61.
61. I'll read 61. The respondent in para 39 of its return has taken a very vague stand. The stamp duty calculated based on the express provisions of Indian Stamp Act and decisions of the Honorable Supreme Court time and again state about the calculation for stamp duty. The petitioner has himself registered 4 documents, that's a mining transfer deeds on 29/6/2017,
based on the scheme sanctioned by NCLT Mumbai and Allahabad. Following documents